Okay, document number 3 was the environmental indemnity agreement. Now, these documents weren't necessarily presented in this order, but this is the order that made sense for me to present it to you guys in. Now, this was a very wordy, very legal document that I had to do a lot of research on, and so that I could translate it in business terms. Um, but this was the document that really protects the lender from liability. So we're just going to go over the 10-page document, had 28 clauses, and I'm not going to go clause for clause, but I'm going to give you the breakdown and the summary of those clauses here. So let's just go through this. So indemnity is defined as a contractual agreement between two parties. In this arrangement, one party agrees to pay for potential losses or damages caused by another party. Okay, this agreement verifies a loan was actually created by way of a commercial promissory note. The loan may be amended, restated, modified from time to time amongst the lender and the borrower. And you'll notice throughout this whole presentation that anytime there's an indemnity clause, they always give that leeway of the possibility of modifying and restating and amending the loan. Okay. It states that the loan is secured by a commercial deed of trust security agreement. And we'll go through that in detail in the next part. The agreement states that the lender would only make this loan with the promise of the following protections against loss or being responsible for. Okay. And here's some of those protections. They're protected against environmental actions threatened by the EPA or the State Department of Environment or any other government agency related to any violation of any environmental law, okay, with respect to any business conducted by the bar on this premises. So, some things that could fall into place would be, uh, hazards that could be on the property, paint, lead paints, any type of violations where anybody, if say someone was cooking meth, that could be an environmental hazard with the chemicals and the dangers of explosion. That's a hazard, which could fall under the environmental laws. So they wanted to make it clear that they meaning the hedge fund, hard money lender, did not want to have any liability involving any of those potential actions. Okay, part 2 of the environmental indemnity agreement. One of the major clauses is the marshaling or the outlawing of marshaling of borrower assets. What is marshaling of assets? Well, I had to look that up, and basically, it is when the probate process is involved. So let me just read to you how Illinois attorney Mario Godoy describes it. Okay, he quotes in his article: "In times of death, the executor of an estate is required to gather and inventory all the assets that were in the decedent's name at the time of their death and liquidate all of those personal property, real property, and stocks into one account in the name of the estate. This is called marshaling. Okay, so it's the inventory, the pooling of all of the assets of the decedent, okay, by the executor. So what this clause is saying is that this property that is has the loan against them in this project cannot be marshaled um, in case of death. It has to be set aside and not marshaled in to the estate. Okay, next, the borrower agrees to cooperate with lender if any events occur that could possibly expose the lender to liability. Cooperation can include providing lender access to the property for inspection, for environmental assessing, and for testing. There are plenty more that we will discuss in future videos. The borrower waives rights to subrogation to the lender as long as the loan is unpaid. The governing laws is at the choice of the lender where the lender does business. In our situation, we did the business in Maryland, but the governing laws were in New York because that's where the lender was based. Okay, part 3 of the Environmental Indemnity Agreement. More clauses and certifications. Okay, the borrower certifies that it is responsible to pay all costs and expenses associated with any collection, sale, or delivery activities associated with the property. Any judicial proceedings that could arise out of the agreement must be filed and submitted to the jurisdiction, which was New York in this situation, but it's the jurisdiction where the lender has an office. Both parties agree to waive jury trial. There's no punitive damage claim that may be made by the borrower against the lender, against any of the lender's employees or affiliates. That's an important protection. And also, in the event of any controversy, dispute, or contest over meaning or interpretations, or even the enforceability of any terms of the agreement, there should be no inference or conclusion drawn against any party. Basically, what they're saying here is that the lender has no intention and the borrower has no intention to deceive or be dishonest or be illegal in this agreement. So if there's any contest or dispute for any clause in the agreement, it needs to be understood that there was no intention of illegality or malcontent at the very beginning. And that would be something important for a judge to understand, that going into this agreement, everyone had good intentions. So that kind of sets the playing field for any negotiations or dispute or conflict resolutions.